Friends, imagine a system where government has huge power, लेकिन कोई control high ना हो. One order, one signature, and a citizen's entire life can turn upside down. To stop this misuse of power, to make government accountable, and to protect the ordinary citizen, we have something extremely important in law. It's called administrative law. And today, we will understand its nature, scope, and its growth in India in the most simple and crystal clear way. Meaning of administrative law. So, what exactly is administrative law? In simple English, administrative law controls how the government works, what powers it has, and how far those powers can go. It ensures that every administrative authority, like ministries, departments, bureaucrats, regulators, tribunals, all act fairly, reasonably, and within the law. Yani, government can't act arbitrarily. It cannot misuse power. It cannot harm citizens without lawful authority. This entire framework is administrative law. Nature of administrative law. Now let's understand its nature, what administrative law is made of. 1. It is a branch of public law. It deals with state versus citizen relations, not private disputes. Though it controls governmental power. It keeps a check on executive actions. Power hai, but uncontrolled power nahi. 3. A combination of judge-made and statute-made law. Courts develop principles. Legislature passes acts. Executive makes rules and notifications. Together, they form administrative law. 4. It is flexible and evolving. As society grows, technology grows, governance expands. Administrative law also expands. It never remains rigid. 5. It enforces rule of law. No one, not even government officers, is above the law. 6. It provides remedies. Like writs, appeals, reviews, tribunals, ombudsman, etc. So overall, the nature of administrative law is dynamic, controlling, protective, and justice-oriented. Scope of administrative law. Scope means what all areas it covers. And trust me, its scope is very wide. 1. Delegated legislation. When Parliament delegates lawmaking power to the executive. Example, rules, bylaws, orders, सब delegated legislation के अंडर आते हैं. 2. Administrative adjudication. Tribunals and quasi-judicial bodies deciding disputes. CAT, NGT, NCLT, consumer commissions all part of this scope. 3. Discretionary powers. License देना, permit cancel करना, approvals देना. These discretionary powers must be used fairly. Administrative law checks misuse. 4. Government contracts. Public contracts, tenders, procurement. All must follow fairness and transparency. 5. Public corporations. Bodies like LIC, RBI, SEBI, ONGC. Their functioning is part of administrative law. 6. Natural justice. The two golden principles. Here both sides audi alteram partem. No one should judge their own case nemo judex. 7. Judicial review. Courts checking whether government actions are legal. 8. Ombudsman, Lokpal, Lokayukta. Bodies to control corruption and maladministration. 9. Public interest litigation, PIL. Citizens questioning illegal or unfair state actions. So the scope covers almost the entire functioning of the modern state. Growth of administrative law in India. This is the most interesting part, how administrative law grew in India. 1. Expansion of the welfare state. Post-independence, India became a welfare state. Government entered fields like education, health, employment, industries, poverty alleviation. More power, more control needed, administrative law grew. Though increase in delegated legislation. Because Parliament cannot make every detailed rule. Executive makes thousands of regulations. This increased administrative control. 3. Growth of tribunals. To reduce court burden and provide expert justice. CAT, NGT, SAT, NCLT, सब इसी growth के examples है. 4. Judicial activism. Courts started monitoring government actions more strictly. PIL, human rights cases. Environmental cases all contributed. 5. Technological and economic reforms. New regulators were created. TRAI, SEBI, IRDAI, CCI. Each regulator follows administrative law principles. 6. Anti-corruption mechanisms. Lokpal Act, RTI Act, vigilance bodies. All are major additions to administrative accountability. 7. Constitutional principles. Articles 14, 19, 21. These fundamental rights strengthened administrative fairness. And that's how administrative law in India became one of the strongest systems of governmental control. Why administrative law is important today? Today, the government touches every part of a citizen's life. Schools, hospitals, industries, transport, taxes, environment, internet, everything. So administrative law is essential to control misuse of power, protect citizens, ensure transparency, maintain fairness, promote accountability, strengthen rule of law. In short, it keeps the government in check and keeps democracy alive. So friends, that was administrative law, its meaning, nature, scope, and growth in India. Explained in a clear, simple, and balanced English style. If you understand administrative law, you understand how the modern state actually works. Thank you for watching.